kicking off then? Quick refresher. When Labour won the election, they vowed to publish a bill within the first 100 days of office, setting out how to put their plan to make work pay into practice. So did they achieve that goal? Well, they presented the bill on day 98, so tick. And read alongside their next steps paper, it does have the potential to be the biggest change to employment law that we've seen in a generation. One prominent employment law commentator suggested it might be the most ambitious set of reforms since 1971. However, it is clear that to meet that self-imposed deadline, there have been a number of fudges, concessions and kicking the can down the road. So there's some measures that haven't made it into the bill, others that are going to be subject to extensive consultation, and others introduced by secondary legislation like regulations. So there's a lot of stuff that's deferred, but don't let that detract from the importance here. There's still some big stuff in there. So getting started then, the number one biggie, day one unfair dismissal rights. Quick history lesson. Unfair dismissal protection's been in place for 50 odd years now, and in that time we've seen the qualifying period fluctuate between 6 months and 2 years. But it's never been a day one right other than in very limited circumstances such as whistleblowing or discriminatory dismissals. And that's going to change because under the bill, any qualifying period is removed. Now, actually, government always had the power to give day one unfair dismissal protection by statutory instrument. So theoretically, if they wanted to, they could abolish the current qualifying period by the new year. But don't panic yet. Don't start amending all your contracts and practices quite yet because they don't want to do that. The government recognise what a big change this is and the impact on working practices it's going to have, as well as the pushback that they'll inevitably have from business. And so they've expressly stated that they won't be introducing this change until autumn of 2026. So we've got 2 years. Now, what that actually means is we've got a 2-year transitionary period. Because if you think about it, the qualifying period for new starters is going to gradually reduce until autumn 2026. So someone starting today will qualify for unfair dismissal protection in 2 years. If they're recruited in a year's time, their qualifying period will effectively be 1 year, and so on until recruits are taken on in autumn 2026, the changes are in force, and they'll immediately attain protection. Coming back to my point that had the government wanted to, they could have introduced this quickly through secondary legislation. Well, because they're not doing that, on the current proposal, once it's in, it is intended to be permanent. So we're unlikely to see the fluctuation that we've previously seen. And that's because the way the bill is drafted is to completely repeal the section that provides for a qualifying period. And that means to reintroduce one is going to need primary legislation. That takes time, that takes effort. So it's likely this is going to be here to stay once it comes in. Who does it apply to? Well, other than in the usual circumstances that garner extra protection, like discrimination, whistleblowing, we're looking at day one of employment, not day one of the contract of employment. So in other words, the employee has to have started work to get the protection. Other than in those limited circumstances, it's still going to be possible to terminate a contract before the start date if you need to. Well, all of that seems relatively straightforward, and then we get into the more contentious stuff. And we've seen there's definitely been some concessions made here from the original proposal. The intention is now for there to be an initial period when a light touch procedure will be permitted. So it's a statutory probationary period, if you will. And during that initial period, it appears the intention is to enable employers to dismiss an employee for performance, conduct, statutory ban, or for some other substantial reason related to the employee, and that's an important part, without go through as full a process as they would usually be required to under the unfair dismissal regime that we're familiar with. Now, I'll come back to that. Note that this seems to expressly exclude dismissals for redundancy or reorganisation reasons. So new starters are going to be need to be treated in the same way as everyone else if you're going through a reorg or redundancy consultation. I think the real questions are going to be around the initial period and the light touch procedure. What's that actually going to mean in practice? Well, we don't know. It's going to be subject to consultation. We've already seen the pushback from business on this one and the concessions that have already been made. I think, though, we'd all been expecting a 6-month probationary period, but it now seems that 9 months is the favoured option. I guess that makes sense, as contracts will often allow for a 6-month probationary period with a 3-month extension if needed. What sort of procedure is going to be necessary during that initial period? Well, again, the bill doesn't say. The next steps document suggests that simply holding a meeting could be enough, but we should know the exact nature of it following consultation. There's a few different approaches that they could take here. They could modify the test for reasonableness during the initial period. They could simply require tribunals to take the probationary period into account when assessing fairness, or they could introduce a specific procedure that must be followed. Now, I think all employment lawyers and HR professionals who were practicing between 2004 and 2009 could be twitching nervously at the possibility of something akin to the statutory dispute resolution procedures being introduced. So we're going to hope that's not the case. What should employers be doing now? In reality, probably nothing right now other than wait and see. Consultation isn't going to start on this till 2025, and the government have said that these changes won't come in until October 2026. So we've got a while yet, but when they do come in, it's going to be a major change. If you want to get a head start, and this is good practice anyway, start reviewing your recruitment, your onboarding practices, and provide training to managers on the proper performance management and assessment of new starters during probationary periods, something I often hear HR moaning about in terms of their managers. Let's get this as established practice before we know what the formal procedure is we're going to have to follow. Okay, moving on, we have fire and rehire, or dismissal and re-engagement as it's often known. Let's be honest here, this one is a big win for the trade unions. The practice of fire and rehire has been in the press a lot over the last few years. Big businesses such as British Airways, British Gas, Tesco's, all getting significant media attention over their use of these tactics to change terms of employment when those changes couldn't be achieved through negotiation, consultation and agreement. Well, it looks like that's going to be a thing of the past. The bill is going to make it automatically unfair to dismiss an employee for refusing to agree a change in terms. So the long and short of this is that once you've agreed terms with an employee, you're pretty much stuck with them. You're not going to be able to force through a change. There is going to be a narrow exception to this, where the business is in financial difficulties that would affect its ability to carry on the business. But to rely on that exception, it seems that the business is really going to need to be in dire straits, and the employer is going to have to show that it couldn't reasonably have avoided making that variation. So it's not going to be enough just to say, well, we need to save a few quid. Now, that's pretty powerful stuff, particularly when you consider that the 2-year qualifying period will have gone as well. We're no longer, in this context, going to be talking about dismissals being within the range of reasonable responses. Given how narrow that exception is and the potential impact on the ability for employers to carry out variations and in some cases reorganisations, employers might seek to find ways around it. One suggestion could be a greater reliance on variation clauses in contracts. Now, drafted properly, this could allow an employer to vary a contract without seeking the employee's agreement. You'd have to avoid breaching trust and confidence, so you don't risk constructive unfair dismissal claims, but case law has generally found a well-drafted variation clause to be effective. However, before you all start rushing to instruct me to draft you a fabulous new variation clause, we probably need to pause, hold fire. It's likely that this will come up for discussion in consultation, and there may well be a debate on whether, to give the proposal real bite, this loophole needs to be closed. Okay, harassment. Let's touch on the changes in the law of harassment because it's another important one. We'll start with third-party harassment. And by this, I mean harassment of employees by people who aren't other employees in relation to any protected characteristic. So the current position is that employers are not directly liable for third-party harassment. They used to be, that was repealed. From the 26th of October this year, this is changing to a limited extent, with new laws putting a positive obligation on employers to take reasonable steps to prevent sexual harassment in the workplace. Hopefully you all know about that already, and I've started making whatever changes you need. If you haven't, get in touch quickly. But employees can't sue directly for breach of this. Enforcement is by intervention from the Equality and Human Rights Commission. So it only applies, it only applies to third-party sexual harassment. And the bill seeks to change this and places direct liability on any employer who does not take all reasonable steps to prevent third-party harassment of any kind, not just sexual harassment. And note, this isn't just reasonable steps, it raises the bar to all reasonable steps. What does that mean? Well, again, we're told that this will be set out in regulations and through guidance. But this is an area where you could start looking at where you are and what you could do. So consider whether you've got clear policies around third-party harassment in place and whether all employees are aware of them. Look at your processes for reporting and handling complaints and ensure that managers are aware of their role in that. If you haven't already carried out risk assessments into potential areas of harassment risk, take this opportunity to start carrying these out. This is a major shift, and whilst hopefully we'll understand more about what is going to be expected from employers in due course through the additional guidance that's going to be released, it certainly wouldn't hurt to start considering particular areas of risk for your business, because it's going to be different for each business. Start considering that now. Finally, on that point, sexual harassment protection is strengthened even further by becoming a qualifying disclosure for the purposes of whistleblowing law. Now, initially, like me, you might think, well, that doesn't have much teeth. We've already got protection against victimisation under the Equality Act. But by classing it as whistleblowing, not only is there protection against discrimination, but the employee can't be silenced by an NDA in a settlement agreement. So it's now going to fall within that list of matters which are excluded from any confidentiality provisions. Okay, moving on again to flexible working. The current position, as you know, employees can request changes to their working arrangements up to twice a year, and employers can refuse the request for one or more of 8 specified reasons. Although those 8 reasons are still the same, they're still going to be in place. The change is that employers must now explain why it considers the refusal to be reasonable on that ground. Now, that requirement to provide an explanation is likely to open up more challenges to employer decisions on flexible working. The penalty is up to 8 weeks pay for breach, and that remains the same. That's not changing. So some might say that that actually puts this into the category of somewhat underwhelming. But in terms of preparing for this, you can start auditing your workforce practices, look at what flexibility you already have in place, what you might be prepared to agree to in the future, where you've previously refused flexible working requests, review them. Do you still want to refuse? And if you do, make sure you're able to explain why it's reasonable. So whistle stop tour of the first few changes. I'm now going to pass over to James to look at some of the other key provisions.
Thank you, Sue. That's great. One thing I would say, whilst Sue's been speaking, we're going to have a quick look at the Q&A section. I can see Ed Bowles posed a question there, which we'll get to at the end. But other than that, there's not too many there. So if you do have any questions at all, do feel free to stick them straight in that Q&A section, because we will we will get to them at the end if at all possible. Right. Bear with me. I think I'm asking Sue for control.
Oh, right.
Quite
I'm not
right.
getting that notification. I don't know how to, so I'm going to just do it for you, if that's all right.
By all means. Yeah.
Okay.
Perfect. So the first bit that I'm going to cover is some changes there on parental, paternity, and bereavement leave. Hopefully, a lot of you will be aware at the moment there's already unpaid parental leave, so up to 18 weeks leave to child's 18th birthday. That's already in place, but that's now going to become a day one right, because at the moment it requires a year's service. Also, unpaid bereavement leave is going to become a day one right. And the parental bereavement leave provisions that are already in place are going to be replaced with wider bereavement leave provisions applying to the loss of a wider group of persons, although how far that stretches at the moment is going to be determined by sort of future regulations. In reality, are those big changes? Probably not. In reality, I think experience dictates that unpaid parental leave and unpaid bereavement leave aren't exactly the most widely utilised rights in the first place, so probably not a major change there. Paternity leave, so that's the right to statutory right to 2 weeks leave. That's going to become a day one right rather than requiring the sort of 26 week service at the moment. But interestingly, no changes at all regarding shared parental leave, which is rather a missed opportunity because it is absolutely horrendous. Be interested for anyone on the call's thoughts as to how widely utilised that's actually been, because it is so complicated and awfully sort of put together, but no mention of any changes in that respect just yet. Next slide, please, Sue. So SSP, a big one, which I think is a bit of a cause for concern for a lot of people. So change there is that SSP is going to be available from the first sick day rather than the fourth day. So no waiting days anymore. As you can appreciate, pretty hefty change that. In some respects, that's going to make administrative payroll processes a little bit easier in terms of linked periods of absence and whatnot, but quite a significant shift there. Where it gets a bit interesting and a bit complicated, so the other aspect is that the lower earnings limit, so £123 a week, which you need to meet to qualify for it at the moment, is going to be removed. What they're then going to do is set out a lower level of sick pay for sort of lower earners. So the idea is that the Secretary of State sets SSP as a percentage of weekly earnings. So even very low earners will essentially get a percentage-based rate of SSP depending on how much they earn over a sort of average. How exactly that's going to work, yet to be determined. There is going to be consultation on what the percentage replacement rate is going to be below that sort of current flat rate of SSP. And that's going to be brought forward through government amendment to the bill during the sort of passage through. As I say, additional calculations are going to be required for low earners. Clearly, that's going to be a bit of an additional chore from a payroll perspective, however it's done. Realistically, what's that going to look like? Probably very similar to the way that sort of statutory maternity pay or whatever else is sort of calculated at the moment in terms of that backward-looking averaging over a probably 12-week period or something along those lines. But yeah, the exact percentages and mechanisms haven't been decided yet. So a little bit of a case there of waiting to see exactly how that's going to operate. But if you use external payroll providers, etc., this will be very high on their agenda in terms of working out how to make it all work. But that is going to be a major shift for employers. Anything else that could be done on that at the moment? Probably not in any meaningful way. I mean, the concern or suspicion there is that that's suddenly is it likely to then make the rates of sickness and absence shoot up, with people being a little bit more inclined to be willing to take an occasional day, also knowing that they will get some sort of sick pay in connection with that? Quite possibly. Time will tell, but certainly worth reviewing sort of current sickness absence rates, etc., within the organisation, if you haven't done that in a while, just to get a good benchmark around what that's looking like at the moment. Next slide, please, Sue. So yes, 0 hour minimum hour contracts, another biggie. I think a lot of people would have been aware that it's been part of the Labour objectives for a very long time to ban 0 hour contracts. They haven't gone quite as far as that, obviously, which I think most people, in the world of HR, always thought that was a ridiculous suggestion to ban 0 hour contracts altogether, not least because everything suggests that a lot of people on 0 hours contracts like being on 0 hours contracts because of the flexibility and everything else. What the bill is introducing is a right to a guaranteed hours contract, reflecting the hours that qualifying workers work regularly over a yet to be specified sort of reference period. The reality, though, is all of the crucial details are left to be specified by sort of future regulations. In reality, this is a rather foolish way to sort of go about it. What should have happened realistically is that they should have said, right, we're planning to do a change along these lines, let's consult over it and then bring in legislation based on the consultation. But because of this sort of commitment to introduce this within sort of first 100 days, they've done it back to front, basically, and have sort of done a very strange bit of legislation and then said, right, we'll then consult over the specifics of how we actually implement it. Broadly speaking, though, qualifying workers will also be entitled to reasonable notice ahead of any changes made to their working hours and compensation if their shift is cancelled or ended early. A key point here is, while the employer is going to be required to offer that guaranteed contract after the reference period, the worker won't be required to accept it. So there is scope there to be able to, in a sense, maintain those 0 hour contracts and things that have the flexibility for individuals in the same way, but weirdly you will be compelled to offer them something as a sort of more regular guaranteed hours basis based on what they work. There are loads of problems with this, which I think we will have to see what the regulations look like. I mean, a massive obvious one is sort of seasonal workers, etc. So bizarrely, you have a seasonal peak, let's say over sort of summer or over Christmas period. You're then obliged to somehow offer that person, a guaranteed contract on those enhanced hours at the end of the seasonal peak, which is a bit of a farce, really. Hopefully, therefore, the consultation will build in some scope around genuine ability to use sort of fixed term contracts around seasonal peaks and things like that to guard against the problems that this sort of gives rise to. What they're going to do as well, though, is consult on what should constitute low hours as opposed to sort of 0 hours, because you can sort of see if there is an obvious loophole for certain employers to say, right, rather than a 0 hours contract, we'll just offer a 1 hour a week contract that we can sort of top up. So there will be a degree of consultation there around what actually does low hours mean in practice, and the commitment there is to find something that should be reasonable and proportionate both for employers and employees. So time will tell, but that will be quite a major shift. Again, there will be an enhanced obligation on employers realistically to monitor those hours undertaken by people under these types of contract, and to proactively offer these contracts, which will be a lot more admin and effort involved by employers realistically. Next slide, please. So collective redundancies. For those of you on the call who are HR practitioners, you may or may not be familiar with the Woolworths case. Realistically, what the Woolworths case involved is around collective consultation on redundancies. So there's 20 or more proposed redundancies being made. The rule is that you have to do elections of employee representatives, and it's a much more substantive, involved process, basically. What the Woolworths case essentially established was that when you're looking at that 20 or more redundancies, you look at it from a perspective of essentially individual sites. So within Woolworths, it wasn't 20 or more redundancies across the whole of Woolworths. It was whether there was 20 or more within each individual Woolworths store. Now, what's changing there is that it's shifting to basically say it's 20 or more redundancies across the entire organisation. So if you're multi-site, you've got lots of different shops or establishments. You can't get away anymore with treating them separately on a sort of redundancy process. The whether or not you hit that magic 20 figure is based upon looking at the organisation as a whole. In real terms, what that means is, I think Sue and I and most other employment practitioners know, the fact that it's been establishments has saved quite a lot of effort and energy in a vast number of cases when looking at redundancies. It will undoubtedly mean there's lots more occasions when there will be a need to do the more in-depth collective consultation process involving election of employee representatives, etc., etc. Again, is it worth preparing for that now? Probably not. Well, unless you're planning on doing a large-scale redundancy in the near future across multiple sites. What it may well mean, though, is that it becomes more worthwhile for employers to look to set up employee consultative forums where there are elected representatives already in place, basically, to be able to sort of consult with on collective redundancies or TUPE exercises, etc., etc. Next slide, please. Enhanced maternity protection. Fairly uncontroversial one to a degree. What's happening here is protection against dismissal is going to be strengthened for pregnant women and those returning from maternity leave. Again, to a very large degree, devil will be in the detail, but the government intends to make it unlawful to dismiss within 6 months of their return to work, save in specific circumstances, which presumably will remain to be seen. But one would guess, if there's clear-cut gross misconduct or something like that, it's still obviously going to be perfectly lawful to dismiss in those circumstances. Worth mentioning, though, is that the maternity leave amendment regs 24 came into force in April, which didn't herald not with a great deal of sort of publicity, actually, but we have seen a few examples where it has caught employers out already. What those have already done is extend the right to be offered suitable alternative vacancies in redundancy situations to employees who are in the protected period of pregnancy. So in the broadest sense, sort of 18 months after the birth, which will often then inevitably cover a period of time once the person has returned to work. We've seen that catch a few people out already. So actually, if you are doing any sort of redundancy exercise where it involves someone who is on maternity leave or who has recently returned, do take some advice, be very careful, because it's very easy to get caught out. But in the meantime, yes, be aware that those enhanced protections are also coming through, so it won't be too long down the pipeline. Next slide, please. Trade unions. there is a huge amount in the bill about trade unions. Very conscious that actually, particularly within the sort of southwest, union activity is not as great as it is in other areas of the country. But there are a lot of changes with regard to unions within the bill. Perhaps unsurprisingly, given that it's driven by Labour government, who is heavily supported by trade unions. So very headline level around that, the bill is going to amend the Trade Union Act 2016 and repeal the Strikes Minimum Service Levels Act 2023. One thing that will be relevant for everyone on the call, whether you recognise a union or not at the moment, is that employers will, slightly bizarrely, be required to give workers a written statement advising that they have the right to join a trade union at the same time as providing the Section 1 statement. So there will be a change that every employer is going to have to make there around, once again, having to adjust what goes in that sort of initial written contracts of employment that we have with people. Sorry, my phone is telling me to shut up, but I will carry on for a minute. The access arrangements are also going to be introduced, allowing trade unions the right of access to workplaces, and amendments made to the conditions of trade union recognition to make the recognition process easier. In terms of the right of access, I'm not sure that's necessarily a particularly concerning provision. The point around it being far easier for trade unions to gain recognition, however, is quite significant. I think it will mean, from an employer's perspective, the more you are, if you are not overly keen on trade unions and having trade union recognition within your workplace, it probably does mean that it makes sense to start to consider whether there's anything you can do to legitimately, fairly sensibly push back against that in terms of being a little bit more proactive around engaging with employees, making it clear that they are getting all the benefits without necessarily needing trade union involvement there. Protection against detriment for taking industrial action. It's also going to be introduced. Again, nothing hugely concerning there, but yeah, I think the takeaway message probably for everyone on the call there is certainly around this need to make the tweak to Section 1 statements, and also just an awareness that it will be easier for trade unions going forward once this is all implemented to push to gain recognition. Next slide, please. Anything else? Just very quickly, there's a few bits and pieces that were heavily publicised in advance of the bill that people were expecting to see, and what's happening with those. One was this right to switch off, which is this essentially a right not to be sort of contacted outside of normal working hours, etc., etc. Not in the bill, basically. The reality is that's going to be brought in by way of a statutory code of practice, which we shall wait to see what that looks like, but nothing greatly to worry about there, certainly for the time being. Single worker status, again, that was a very big one, which would be an absolutely enormous change for geeks like me and Sue, in particular around the impact that different employment and worker statuses have. The idea there was to potentially have a single status, but the different statuses of worker, employee, and self-employed flow through so hugely into almost every bit of employment law that is an absolutely enormous change that would require a huge amount of amendment of legislation and practical adjustments to implement. So they have pulled back on that to a large degree and essentially sort of said, right, we will consult on that to try and explore a way forward. So absolutely no realistic chance of anything major happening there in short order at all. Minimum wage bands, as you all on the call probably appreciate, there's different age bands linked to minimum wage at the moment. The government's going to try and remove those. So essentially ensuring that every adult worker gets almost a sort of flat rate of minimum wage. If you employ a lot of young people at the at the very low rates of minimum wage, that may well be worth factoring in. That change is sort of coming, but no clear-cut sort of proposals in the bill on that as yet. They're also going to develop a menopause guidance for employers and guidance on health and well-being, which again, worth being aware of, but nothing too scary there. What we're also going to see separate from the Employment Rights Bill is that there is this sort of commitment to begin consulting on the Equality, Race and Disability Bill in due course. Everyone was sort of anticipating that the bill might actually be published around about the same time as the Employment Rights Bill, but no joy there. So that will be a lot of the changes that were anticipated as part of that are a bit of a way off, but the indication is that will look to extend pay gap reporting to ethnicity and disability, which will be fascinating to see exactly how that's proposed to work, given that most employers don't capture the raw data to be able to do the reporting. It will extend equal pay rights on the basis of race or disability. Again, quite a challenging one to actually implement on a practical level. Ensure that outsourcing of services can no longer be used by employers to avoid paying equal pay, and implementing a regulatory and enforcement unit for equal pay with involvement from trade unions. So nothing immediate on any of those things. Worth bearing in mind that the commitment is still there to look to do that, but it will all be subject to consultation, so quite a way off, I think it's fair to say. Next slide. Aha, we get to questions.
Thanks, James. There's been a few questions come in. I'm going to start from the bottom. The first one's, will the session be recorded? I believe it is. I believe I've got much cleverer people than me sorting that out, so we can circulate that, and feel free to share it with colleagues if you wish. Ed Bowl, thank you. I'm confused. Yeah, me too. An employer has to take reasonable steps to prevent sexual harassment from its own staff, but all reasonable steps to prevent sexual harassment from third parties, or is it the other way round? Okay, so we're doing this in two steps. From the 26th of October, we're only talking about sexual harassment, and that's the new law that's coming in, is you have to take reasonable steps to prevent sexual harassment from your own staff or third parties. What the bill is going to do is increase that new law and say all reasonable steps, and then add separately and all reasonable steps to prevent third party harassment on any grounds, not just sexual. So that's not in yet. Well, neither of them are in yet, but from the 26th of October, we've got the reasonable steps, not all reasonable steps, not clear what the difference is anyway, and that sexual harassment from your own staff and third parties. I hope that's slightly clearer. Will we get a copy of this presentation? Yes, I think so. I think we're going to be able to send that out. Angela, can you refuse a flexible working request based on an employee having already made 2 in 12 months? I don't think that's changing. Haven't seen anything unless you have James suggesting that will change, which means, yes, you can. I've managed to squash that. So where are we?
I think the next one was Denise said,
SSP.
is SSP payable during probationary periods? Yes, that is the way it's looking at the moment. So essentially it's somewhat bizarrely, it looks like it will be a sort of day one right, which is fascinating to think exactly how that will work. I think the devil will be in the detail on the sort of regulations, but yes, SSP would be payable during probationary periods. Again, fascinating to see how on earth that will work in terms of the being able to create some sort of average of particularly for lower earnings staff. So they're going to have to come up with a way of dealing with that, which will definitely be one aspect of the sort of consultation, without doubt.
So when does day one SSP come into force? I haven't seen a date yet, but I do think that we're expecting that to be one of the quicker things to be put into force, to be brought in. I think we're expecting that relatively quickly, but that's a rubbish answer because I don't know what quickly means at this point, unless you've seen anything, James.
No, so the only real guidance there that we've seen thus far is there will be a consultation on what the percentage replacement rate for those earning below the current flat rate of SSP should be. This change will be brought forward through a government amendment to the bill during its passage. So that's about as much as we know realistically. But I think one interesting aspect is, so bear in mind, I think in particular for the SSP piece, there is a fairly wide commitment on the part of the government here that, or a recognition at least that some of these changes are quite big and will need, employers and companies will need time to adapt. I think the SSP one in particular, there is undoubtedly a recognition there that, well, that it's a major change, but I think the reality is it requires quite a lot of adaptation on the part of businesses and payroll providers and everything else to actually build and implement systems to be able to track it and actually implement it properly. So I think the reality is I'd be inclined to say there's very little realistic chance. I'm going to be really bold and say there's no realistic chance. Yet certainly in the first 6 months plus of 2025, at the very least, there's no real chance of that have much scope to sort of be put in, just because it will take time to implement the systems, do the consultation around the different bits and pieces. My guess would be we're probably looking at 2026, but that is a bit of a guess. We will know more in due course.
Great. Donna, relating to the redundancy and maternity protection, I assume you mean that which is already in place. Presumably those being caught out already haven't yet got to tribunal. I'm not aware of any cases, James, are you? That already reached the tribunal?
Sorry, just get the question. No, none of them. Not that I've seen reported at all yet. I've seen cases with employers who have essentially been caught out but managed to nip it in the bud before it escalated, if that makes any sense. So I've seen ones where the person has been selected for redundancy and then the person themselves has pushed and said, actually, you are obliged to, and the employer has then sort of said, oh, is that right? And got away with it, basically. But yes, so far as I'm aware, I haven't seen any in the actual make it as far as tribunal yet. Although there's probably also an element there of the people who have been caught out would there's probably an element there of not wanting to be the sort of test case in a tribunal and have settled them fairly cleanly early doors. But yeah, be aware. I think, as I say, on that side of things, it is probably just being aware that if you have an employee who is on maternity or has just returned from maternity, particular extra care is needed, and taking some advice and getting that right, making sure of your position before you leap in.
Okay, thanks, James. I'm conscious it's 1 o'clock. I don't think I've really got an answer for this one, but David, really, really good point, particularly for local authorities about collective redundancies and its application where they're the employers of schools and and it could cross an awful lot, and are schools going to be taken into consideration when looking at that 20? I don't think that's been anticipated. Well, I'd like to think it's been anticipated, but I don't think it's been addressed yet in the information we have got about collective redundancies. So I would hope that it will be addressed, because that's going to be really, really relevant.
Although, as an interesting point there, David, I have seen that point raised in some of the sort of commentary around this in terms of it being an obvious issue. So it will undoubtedly form a fairly significant part of the sort of consultation exercise around it, because you're absolutely right. That is a bit farcical, frankly, if it would apply in that sort of scenario.
Yeah, it's just not practical, is it? We're going to have to finish now. If there's any other questions, we'll try and respond to those separately, but I'm conscious everyone's given up enough of their time. So thank you very much for joining us. We'll get the slides and recordings out to you. We're really keen to, we recognise this is the first step. This is the first step on what's going to be quite a long and tortuous journey, and we're really keen to keep supporting all of our contacts along that journey. And we'll keep you up to date with developments as they come through. At the moment, we're thinking that we'd like to, at some point, put in some in-person workshops once we know a lot more, to really work through the practical changes and considerations. So what we're going to do after this is send out a survey to all, see what sort of thing you'd like in that way, where you'd want them, what you'd want them to cover. So it'd be really helpful to us if you would take 2 minutes just to fill that in and return them. But thank you all for joining us, and we'll keep you up to date.